Today we are going to discuss the topic banker and customer, what is meant by banking and the meaning and definition of banker and customer and banking company, and what are the relationship between the banker and his customer. This is the topic today we are going to discuss. Okay. What is meant by banking? According to section 5B of Banking Regulation Act 1949, accepting for the purpose of lending or investment of deposits of money from the public, repayable on demand or otherwise, withdrawable by check, draft, order or otherwise. From this definition, we clearly know about the activities done by the banking company. Every banking company have to accept deposits from the public, and that deposited amount may be utilized by them for making lending or investment. That amount must be repayable when the particular customer can have demand and show it in the order form, and or withdrawn money by issuing check, draft, order or otherwise. This is the meaning and definition given by the Banking Regulation Act 1949. Now, let us know the term banker. Who is said to be a banker? According to Herbert L. Hart, a banker is a person, one who in the ordinary course of his business honors checks drawn upon him by persons from and for whom he receives money on current account. So, this definition provided by the author Herbert L. Hart. According to his definition, who is doing the banking business, he must be a person. That person means a company, that is one form of organization, and their function is to honor the checks drawn upon him by persons from and for whom he receives money on current account. This theory is not widely accepted by all, as he mentioned only the current account, not other type of deposit account offered by the banker. So, according to Sir John Paget's definition, no person or body corporate or otherwise can be a banker who does not take deposit account, take current account, issue and pay checks, collect checks crossed and uncrossed for his customers. So, he defines clearly and include all type of deposit account, which means current deposit, saving deposit, any type of deposits he included, and current account also, and the other functions performed by the banker is also included under this definition. So, this definition is widely accepted by all. Now, let us come to the point, what is meant by customer. A customer is a person who has some kind of account such as deposit or current account with a bank, and from this it follows that any person may become a customer by opening a deposit or current account or having some similar relations with a bank. So, to constitute a customer, there must be an account opened by the customer, and also he must have regular and habitual dealings, and also the dealings must be in the nature of banking business. We should also know the legal requirements to be a qualified as customer. In that view, customer should be a major person, not a minor, and customer be of a sound mind, and he should not be debarred under any law. There must be an offer and acceptance of the proposal, that is the banker and the customer, offer and acceptance, banker and the customers. Now, we are going to discuss the relationship between a banker and his customer. The relationship has been classified into two. One is general relationship and another one is special relationship. General relationship further classified into several categories that will be debtor and creditor relationship, agent and principal relationship, trustee and beneficiary relationship, and bailor bailee relationship. When a customer deposits money with a bank, the relationship of debtor and creditor will be established. In this case, the banker is the debtor and the customer is the creditor. It is the basic rule of banking law that in case of a general deposit of money in the bank, at that moment the banker will become a debtor as he has the amount of customers in his hand. And at the same time, when the bank lend some amount to the customer, at that time the banker will become a creditor and the customer should be a debtor of that bank. Then another relationship between the banker and his customer is agent and principal relationship. This relationship creates some sort of agency services performed by the banker on behalf of his customer. So, in such a way, the banker is an agent and the customer is acted as a principal. So that the banker should follow the instructions given by the principal. So, to show required skill and carefulness and duty to provide proper accounts and duty to pass on any benefits derived from agency. These are the duties performed by the banker as an agent of his customer. Do you understand? So, when the banker serves as agent of the customer, that is principal, some of the agency activities of a banker are specified, like collecting checks on behalf of the customer, collecting dividends and bill of exchange, and acting as an attorney, representative or executor or of a customer, and buying and selling securities on behalf of his beneficiary. A trustee is a person who holds the property of for the beneficiary, and the profit earned from this property belongs to the beneficiary. If the customer deposits securities or valuables with the banker for safe custody purpose, banker becomes a trustee of his customer. Okay. Next one is bailor and bailee relationship. Bailment is the delivery of goods by one person to another for some purpose upon a contract, that they shall, when the purpose is fulfilled, be returned or disposed of according to the directions of the person delivering them. So, the person delivering the goods is called the bailor and the person to whom these are delivered is called the bailee. Bailment is also an important type of relations between the banker and his customer. It may arise in several situations. For example, availing safe custody services, that is safety lockers we may use with the help of our banker to keep our valuables, documents, jewels, etc. Then pledge of stocks as security for availing credit from the bank. So, in these cases, customer is the bailor and the banker is the. Now, we are going to discuss about the special relationship between a banker and his customer. The special relationship is classified mainly into two. One is obligations of a banker and another one is rights of a banker. First, let us discuss obligation to honor checks. It is the statutory obligation of every banker to honor his customers' checks. How can the banker can honor the customers' checks? according to certain conditions. According to certain conditions, that is sufficiency of funds. If the particular customer raised demand in the order form of check, he must have sufficient funds in his account. Then only the banker can honor the customer's check. And the amount must be applicable to the payment. It must be free, not attached by any legal restrictions. Then the requirement must be arised from the customer during the working hours and working day in a proper form. Then only the banker can honor his customer's check. And the check must be presented within a reasonable time into the hands of the banker. We all know that particular check's validity may be 3 months at present. So, the date mentioned in that particular check, from that date until the 3 months validity, the banker can honor the check. So, it must be presented before it becomes a stale one. Then there should not be any orders received from the court for any occasions, which is a legal bar which restricts the operations of such account. So, in such a cases, according to the verification of these points, the banker can have such obligation to honor checks of his customer. Next, we discuss the obligation to maintain secrecy of accounts. It is also the statutory obligation of every banker to maintain secrecy of his customer's account. He must not disclose any information about the customer's account except to certain cases. If it is required by Reserve Bank of India or income tax authorities or any such act, he can disclose. In other cases, he should not disclose and he must maintain the secrecy of his customer's account. It is also the statutory obligation of a banker. Do you understand? Now we discuss the rights of a banker. The rights of a banker have been classified into 4: right of lien, right of set-off, right of appropriation, and a right to charge interest and incidental charges. First, let us know what is meant by right of lien. First, lien is a right to keep possession of a property belonging to someone else until that person discharges the debt they owe you. That means until the repayment of the debt due, the particular person who lends money can have the right to retain the property of the borrower. So, as such, lien gives the banker a right to retain assets, securities or goods pledged as securities or collateral belonging to the borrower until the borrower repays the loan or debt. So, the right of general lien is conferred on the banker by section 171 of the Indian Contract Act. Do you understand? And a banker should exercise his right of general lien only as a banker, not as a bailee. Also, the banker can sell or realize the collateral security only after giving a reasonable notice to the customer who has defaulted. And also the bankers cannot realize valuables deposited with them for safe custody purpose. This is the case of bailment. Hence, the bank cannot exercise the right of general lien in case of bailments. So, from this discussion, a banker cannot exercise the right of general lien in some cases. One is if valuables are deposited for safe custody purpose, and if money or documents are deposited for specific purposes, and if there is an express agreement that the bank shall not exercise this right. These are the things we should know under the right of lien. Then the second right of the banker is the right of set-off. Right of set off gives the banker the power. Which power? To adjust the amounts due to them from a customer against the amount payable by the customer to the banker. So, this helps in determining the net balance payable by one party to another. So, if a customer has two or more accounts in the same bank, the banker can exercise this right of set off. It means the amounts in both the accounts he may use. So, in other words, the banker has a right to combine two or more accounts if needed, but by giving proper notice to his customer. The next right is right of appropriation. Right of appropriation, when the banker can exercise, he can exercise this right under a certain situation. What is the situation? A customer may owe several distinct debts to the bank. When the customer deposits some money in the hands of the banker without any specific instructions, and the amount is also not sufficient to discharge all the debts, all the time barred debts, then the problem arises as towards which debt this amount should be adjusted. In the absence of any specific information from his customer, the bank has the right to appropriate the deposited amount to any loan, even to a time barred debt, but the banker must inform the customer about the appropriation clearly. Then the next right is right to receive interest or charge interest and incidental charges. We all know banker used the deposited amount which is received from the customer only for making lending or investment. If the banker invested that money, he may yield some sort of, if the banker invested it into shares or debentures, he may receive a dividend or interest, isn't it? If he make use of that money in the form of lending to the customer, in such a case the banker has the right to charge interest on loans and advances. What are the loans offered by the banker? It may be a term loan or for a medium term, long term, short term, like that, and also overdraft facility and cash credit facility, and he also provides such kind of advances on the basis of purchasing and discounting of bills. So, in such a cases, it is the right to charge the interest on loans as well as advances. So, a bank also has the right to charge a commission for the services that are rendered by him to his clients. Such services can be nowadays SMS notification services, retail banking services, check collection and other things and other sort of new type of services rendered by the banker to his customer. In such cases, he may charge some amount of commission, and frequently we are all using the fund transfer and RTGS facility and so many IMPS, so many banking services that are used by us with the help of our banker. So, for such kind of services, the banker has the right to charge some bank charges. Okay, I think you understood all these things, isn't it? Apart from these varied rights, nowadays the banker has the right to close the account. How can the banker can close the account? When he may close the customer's account, if it is of the opinion that an account is not being operated properly by his customer, it may do so only by sending a written intimation to his customer. Without intimation, the banker may not close the customer's account, but by giving a proper notifications in a written form to his customer about the non-operation of that particular account, the banker has the right to close his customer's account. Otherwise, he may not be able to close the customer's account. So, these are the relationship between the banker and his customer under the heading general and special relationship. I think you understood the concepts well. We will see in the next video. Thank you all.